Welcome back, America. It's Hugh Hewitt, joined now by Senator Tom Cotton. Senator Cotton, remind me, who taught you at Harvard Law, Con Law?
Dick Fallon.
Did you spend a lot of time on post-tenure impeachment trials?
No, Hugh. We either didn't spend it or I fell asleep or missed that day of class, to which I've had to plead guilty on several topics as well.
Well,
my liberal critics might say I slept through all of law school.
Well, I'm just wondering, because in 25 years of teaching, I know that there is an article by Brian Kalt, a fine professor at Michigan State Law School. I have just never come across the argument that you could have an impeachment for a former official because it's such a terrible idea. What do you think going in? Has anything changed your mind? I know you voted against it to begin with. Has anything changed your mind?
No, Hugh, from the day the House passed this rushed article of impeachment, I have said it was beyond the constitutional authority of the Senate to have an impeachment proceeding to convict and remove a man from office who left office 3 weeks ago. By the time we're done with this, probably almost a month ago. And I think it just doesn't make much sense to many Americans. I understand there are very smart lawyers who have argued both sides of this question. And I've got friends that I respect on both sides of the question. To me, it's a pretty clear question. But the fact that you've got smart lawyers, many of both conservatives on both sides arguing both sides of the question, just goes to show, as many things are in constitutional law, you can argue that it's a close question, but should we really be having an impeachment proceeding against a former president on the grounds of a close constitutional question, if you believe it is close, or should we be focused on the people's business and what's ahead of us and trying to get past this pandemic and get the economy back on its feet? I would argue most Americans think it's pretty strange what they're seeing in Washington this week, and that they want us to focus on their business. That's
the prudential argument. I don't think this is a close question. I read Professor McConnell's, for whom I use his casebook in my First Amendment class. I use Erwin Chemerinsky's in my con law class. They're great people, wise people. It just isn't close, and Justice Story didn't think it was close either. My question to you is a procedural one. If you want to make an objection in the course of this process, and Senator Leahy is presiding, as I understand he will be, does he answer that out of the font of knowledge he has accumulated in his many, many decades in the Senate, or does he have someone who actually knows something about constitutional law at his right hand?
So, Hugh, the typical way that happens, whether it's Senator Leahy or for that matter, the Chief Justice last year, or just in the ordinary course of Senate business, is that we rely first and foremost on the expert advice of the parliamentarian's office. You see them sitting in front of the presiding officer, sometimes whispering in the presiding officer's ear. And those questions have typically been evaluated in advance. The lawyers on both sides of this question have briefed it up. So it's not going to be, I don't think it's going to be a surprise what they argue today on the constitutional question. And we rely first and foremost on the parliamentarians.
But Senator Paul tried to ask a question. The Chief Justice refused to do it in Trump impeachment 1.0. If he tries to do so again in Trump impeachment 2.0 or anybody else, that's not going to be something that the parliamentarian will ever have encountered before. So it will be up to the presiding officer to decide. And I mean, does he get?
Hugh, that's a good question. I don't recall what that question was in the first one. I know on this one, the threshold question is what we considered in a way 2 weeks ago, whether or not we have the constitutional authority to conduct this trial, and the trial procedure resolution yesterday allows for several hours of argument today and then a vote. So we've already kind of laid the table for that vote, and I wouldn't say it's necessarily going to reflect exactly what the vote was 2 weeks ago. Technically, Hugh, the vote 2 weeks ago was a vote to table the motion to dismiss. So one might have voted against that on the grounds that it was appropriate to hear the argument and make a decision. Now, I wouldn't expect any of the 45 of us who voted not to table it. So we wanted to move straight to a vote on the motion dismissed to change our position. But you might have several Republicans, and for that matter, Democrats, who, after hearing the arguments, are prepared to decide that motion on its merits.
Well, we could only hope. That would at least get us out of this. Very quickly, Senator, on the Byrd rule, have you talked to Joe Manchin? Is he going to be strong on the Byrd rule?
I talk to Joe almost every day, Hugh. And Joe has said that he sits in the seat held by Robert Byrd. And the Byrd rule is designed to ensure that our special budget rules only apply to budgetary measures, taxes and spending. not to purely policy measures like, say, D.C. statehood or immigration or minimum wage. Those are the measures that are subject to the legislative filibuster and for which the Senate needs to find consensus and a bipartisan path ahead. So,
and I
take Joe at his word.
I saw you have followed whether or not people not in the country legally are going to be getting benefits from this. Has he weighed in on that yet?
So Joe was one of the 8 Democrats who voted last week not to give stimulus checks to illegal aliens, which I think is a pretty common sense position. It's amazing to me that 42 Senate Democrats want to give your tax dollars to illegal aliens in the form of stimulus checks. But there are 8 Democrats who broke ranks.
Well, it's going to be a wild couple of weeks. Senator Cotton, we'll keep talking to you. Bring along a pen to stab your leg with, because it's going to get pretty dull pretty quick, I think.